Can't start right away either, so let me.
Thank you, and thank you for joining this Making the Modern Estate Plan working with our clients to fund their trusts. The goal of this program is to talk about how financial advisors and estate planners can work together to, for the benefit of our clients as far as making sure their trusts are funded. One of the biggest issues that we see in our practice is people coming in with trusts, beautiful trusts that were set up, say, a decade ago, but they're invalid, really, because there have been no assets transferred to the trust. So I think as part of the service that we can provide together, we can make sure that our clients not only have great documents, but they also have funded trusts, which will make sure their plan works. Before we head into that, though, I want to talk a little bit about the fiscal cliff legislation that passed a couple of weeks ago and the changes that that's going to provide for us in our practices. A couple of months ago, Leslie and I wrote a book called Closing the Wealth Transfer Window, and in that book we talked about two windows. The first window had to do with the changes that were going to automatically occur at the end of 2012, and the second window were the changes that were down the road that Congress could make at any time with regard to endangered strategies. This first slide we're looking at here deals with those changes that were supposed to occur at the end of 2012. So we now have a permanent $5.25 million inflation-adjusted exemption, not only for estate tax, but also for gift tax and generation skipping tax. And this is going to change the way that we expected we'd be doing estate planning at this point. We're going to be doing more of the same of what we were doing in 2012, but with more confidence now that these changes will be around for the foreseeable future. We also have a permanent portable exemption. Now what that means is we don't have to play the games that we've played in the past with regard to the funding of marital subtrusts. We can still create those survivor trusts and bypass trusts and Q-tip trusts if we choose, but now for long-term marriages that are where we have basically a nuclear family, we can take advantage of what are called survivor trusts with a disclaimer provision and create those bypass trusts only if we want to. The final change that really was going to expire on December 31st, 2012 was the 35% gift and estate tax rate. It was supposed to go to 55%, but it went to 40%, really the classic compromise between what the Republicans wanted at 35% and what President Obama wanted at 45%. So we ended up with a compromise of 40%. So this deals with the first closing window. The window didn't close. Really, the whole wall was blown out, and now we have a superhighway allowing us to do planning without focusing on estate taxes as the driver. Now we can focus on what I think are the more important issues, the qualitative issues that all families care about. The second window that did not close, that is still wide open, were what we call the endangered strategies list. So grantor trust were supposed to automatically be included in the estate when a person died. That is not the way the law is currently. Currently we can put provisions in grantor trusts that make them grantor trusts but do not cause them to be included in the estate. And we do that all the time with regard to intentionally defective grantor trusts and irrevocable life insurance trusts. And we don't have to worry at this point about those trusts automatically being included in the estate when somebody passes away. So these advanced strategies that we're talking about are still going to be available. We also can still claim discounts for transfers of non-business interests, such as personal residences, and for transfers of minority interests to family members. So discounts are still available for those types of transfers. They were supposed to be going away, and they still could go away at some point if Congress changes their mind. The 10-year minimum term for grants has not come about, so we can still do the 2-year rolling grants that we've been doing for the past 10 years since the Walton decision. That strategy is still available. We can also still do dynasty trusts. The 90-year limit on the use of the GST tax exemption was not adopted, which means that we can still do trust if you're in the right jurisdiction that could last for centuries. This means that we can continue to make gifts as we were before. So we still have high exemptions, We still have interest rates that are historical lows. We still have depressed property values. So this makes it the ideal time for making gifts. If you want to make a family loan, you could charge a rate as low as 0.87% in January 2013. The Section 7520 rate, which are used for many strategies, is only 1%. We're still at the historical low for these types of strategies, so these strategies are still wide open. But what's going to happen, I think, as a result of these changes is that we're going to see a return to what I call goal-driven holistic estate planning. And this slide lists just a few of those goals, which I think will become paramount, as they should be, as we do estate plans. For example, desired distributions. We can now distribute property to those we love, when we want, how we want, in the way we want, through good estate planning, good documents. We can provide asset protection. We can avoid probate. We can remove appreciation from the estate. We can remove appreciating assets from the estate. We can focus on the decision makers we're naming and making sure we're making good choices there. If we want to incorporate generation skipping provisions into our trusts, we can. We can set these trusts up so they avoid taxes or do not. As revocable trusts, we're talking about the retention of financial benefits and retention of control. That's just part of the strategy when we're dealing with revocable trusts. And we can also leverage the exemption if that's our goal. But I think the focus with the changing law is now going to turn to income tax minimization planning. So I think we're going to see increased use of life insurance trusts. I think we'll see increased use of share remainder trusts. I think we'll see increased use of business planning and retirement planning. But now we come to the last bullet on this slide, which is really the launching point for this presentation today. I think part of the focus of estate planning will now turn to digging into the details. We've been involved in high-end planning and making sure that the plans are in place. Now I think we can dig into the details and make sure that all the T's are crossed and all the I's dotted, making sure that the plan is fully operational and is going to work when the time comes when we need it.
As many of you know, the Revocable Living Trust is the centerpiece of the modern estate plan. It is what we're going to use to name fiduciaries to step in upon our incapacity and death and to handle things without court involvement. And as the rest of the slides we'll go through will show you, the most important thing in that regard is funding the trust. To accompany the document, though, we always have the pour-over will. In case things do not end up in the trust, it will pour over according to in the will at death into the Revocable Living Trust, so it can be distributed according to the trust terms. We also have a durable power of attorney for financial matters, so if you're incapacitated, somebody can handle non-trust assets or get them into the trust before you pass away. In California, we also have an advanced health care directive, which combines the power of attorney for health care along with the living will. In other states, they're separate documents. In California, they're combined. And of course, we always have the HIPAA authorization to circumvent the privacy law, so we can so your named fiduciaries can talk to your medical providers. And as many of us know, the Revocable Living Trust is what is going to avoid probate. Even if now with such a high exemption, we don't need it to minimize estate taxes, we still need it for probate avoidance, and so that the successor trustee can step in upon your incapacity and death, and after death, assets are available and distributed without court involvement. And another benefit of the revocable trust, of course, is that trust provisions are not public, as a probate would be. And then in our practice here, we tend to leave almost, not all of our clients, but most leave the assets eventually to their descendants in lifetime trusts. And it can help them for creditor and divorce protection. The pour-over will, which we hope to never use actually because pour-over wills go through probate, establishes the domicile, and it's where you appoint the personal representative or executor who will handle non-trust assets if they have to be handled at death. But the most important thing we do use the will for is to name the guardians for minor children, and of course it will pour over property into the trust if necessary. But in California, of course, we tend to use what we call a Hagstad petition to get things in the trust. We can list them on a schedule at the back of the trust. If we don't have something in the trust at death, we can go to court, petition the court to get that in the trust and try to avoid probate. So we're always going to try to have the trust funded, number one. Number two, we'll get it in the trust with the power of attorney if need be during incapacity. Third, we're going to use a Hegstad petition here in California, at least, if we can get it in the trust before at death, if it was not in the trust, without going to probate. And lastly, we'll use the will and hope never to use the will. The durable power of attorney for financial matters, as I mentioned before, is going to let your agent handle your assets, non-trust assets, during your incapacity. And so it could be broad, giving as much power as to completely create a trust and change the trust, or usually more specific. Usually we use it here to fund the trust when things are not in the trust during incapacity.
So again, the purpose of this durable power of attorney for financial matters is really to deal with property outside the trust. And in my view, it's one of the most important functions is to make sure that this person, if something happens to the grantor of the trust, make sure that if they're in a coma of some type, this person with the durable power of attorney for financial matters can make sure that any assets outside the trust get into the trust, so if that person passes away, that they'll avoid probate. So this power can either be specific or broad, and it can there are usually provisions preventing this agent from self-dealing, but it does not survive the principal's death. So we want to make sure that this person gets the trust completely funded before the person dies. The durable power of attorney for health care, we call this the pull the plug document. So this allows the grantor of this power to appoint an agent to make health care decisions for them in the event they're incapacitated. It really doesn't have to have much to do with financial management, although pulling the plug sooner rather than later can have a huge impact on the amount of assets available to the survivors. So in that respect, it's a very important decision financially. But this allows people to make health care decisions and allows the agent, this expires at death as well. It's usually a springing power as well, so usually it requires a physician or a physician and a spouse or two physicians or a panel to act together to say that this person can no longer make decisions for themselves. The power is always revocable by the principal, so they can always change their mind with regard to this power. With regard to the HIPAA authorization, this came about, the HIPAA Act, the Health Insurance Portability and Accountability Act, passed in 1996. The regulations didn't become effective, and it didn't become a serious concern for most healthcare providers until early this century. The purpose is to protect confidential patient information and records, and in this document, you can either specifically name the people who are going to have access to it, or you can generally name the people who are going to have access to it. Most states allow you to specifically name the people. Some allow you to name the decision makers you make with regard to your durable power of attorney for health care as your decision makers, and allow them to receive information from doctors and medical institutions. The living will is an expression by the individual themselves to the healthcare providers that they do not want extraordinary measures taken to keep them alive. And some states have statutory forms like California and Missouri. Others have a very general form where the person is just making a statement that if I'm in a vegetative state, I do not want extraordinary measures taken to keep me alive. Some states are very specific about the things that can be done when somebody's in that vegetative state, as far as exploratory surgery or hydration or sustenance. They're detailed, and there's usually provisions, usually spaces on these statutory forms to fill in more specific wishes if you have them. Some states also have a registry where the person can register their living will so that healthcare providers are aware that it's there. We're going to turn our attention now to the main focus of this presentation. With this background we now have on the basic documents and the basic state of the law at this point, we're going to talk about how we can work with our clients to fund trusts. Now, this role is changing. Historically, attorneys have not taken steps to fund the trust. We would leave our clients with instructions on how to fund these trusts themselves, but experience has shown that they don't do it. And so what this has led to is that many attorneys are either funding the trust for them. Usually they at least do the deeds that transfer real estate into these trusts, but some go beyond that, and they actually fill out documents that the client brings to them with regard to beneficiary designations and so on. But in my opinion, this is best handled by working with an advisor. because the advisors see their clients on a regular basis. Attorneys tend not to see their clients as often as financial advisors do. So this is the perfect opportunity to collaborate. And an attorney interacting and collaborating with a financial advisor, we can make sure together that these all these assets that the client owns are transferred into the trust. Now, the financial advisor is probably aware of these assets. The attorney usually asks questions with regard to these assets. So we know what assets are there, and it's just a matter of communicating between the two of us how these assets are going to be transferred. The things to watch for in an estate plan review. So in the work I do with financial advisors, one of the most important roles, in my opinion, that financial advisors serve is they serve as the eyes and ears of the attorney, as far as letting us know when somebody has an estate plan that needs to be updated. And so one of the things I provide to my financial advisors is an indicators an estate plan needs to be updated handout. Now this handout is being distributed along with this presentation, and there are 37 items on it, and it's pretty much the same checklist I go through when a client asks me to review their estate plan. So with this estate plan, and make a referral to the estate planner if there's work that needs to be done. Some of the more basic questions: does the plan distribute the property to whom the client wants when the client wants it distributed? And usually this is just a short conversation with the client, finding out what their wishes are. Does the plan avoid probate? Are there assets outside this trust? Is the trust structured in such a way that it's not going to be go through probate? One of the most common issues I see here are testamentary wills with testamentary trust provisions in them. Those wills have to go through probate in most states in order to fund that trust, which, in my opinion, is not the desired way to do this. Are the right decision makers named? One of the most common reasons people bring their estate plans in for revision is because the decision makers they named 20 years ago have passed away, they're no longer friends, they haven't seen them for years, or maybe now the children are old enough to be serving those decision-making roles when they weren't before. Is asset protection provided? So are there provisions for creating irrevocable trusts and providing other asset protection features like beneficiary control trusts through this plan? So these are the types of things that an advisor serving as the eyes and ears can draw the attention of an estate planner to and the clients to. Another role that financial advisors serve when I work with them is identifying clients who have started to lose capacity. Now this is becoming a bigger issue as the baby boom gets older. So with this slide, I've listed some of the most common factors used to measure capacity. The measures of capacity are different for a will than they are for a trust. When you do a will, you, for the most part, just have to be able to identify your loved ones and identify the property that you own. That's a very low standard. In order to create a trust, you have to have a much higher standard of decision-making ability. Definitely the ability to contract. So it may not be the same ability you need to do a business contract, but it does need to be the same ability to enter a general contract. So you have to have a little bit more sophisticated way of thinking. And the factors you look to are alertness, attention. Are they oriented to their environment? How's their short-term memory, their long-term memory? Are they hallucinating? Are they connected to reality? Are they showing big mood swings just in the period of a short meeting between anger and sadness and depression or fear? Are they able to comprehend what's going on around them? So financial advisors are usually in a better position to identify when people start to lose capacity, and that's the time, if the documents are not in place, that it's important to take steps to get those documents in place before capacity is lost. Within the documents themselves, we have some standards for measuring capacity. And so within the documents, it might trigger the passing of control of the trust assets from a grantor to a successor trustee if incapacity starts to show itself. So the measuring sticks for this might be a loved one. It might be a spouse or a significant other making the decision about whether a person has lost their ability to make decisions. It might be an attending physician making that call. It might be a loved one in an attending physician. You can see the standard gets a little stiffer as we go down this list. 2 licensed physicians might be required, a disability panel, a court. In some situations, we just automatically appoint successor trustees to manage trust assets when the grantor has been kidnapped or has disappeared for a period of time.
Well, by far, one of the most confusing areas for clients is funding the trust. And it's so important, and as Randy mentioned earlier, we see so many unfunded trusts. So we fund them here at our office. We work with financial planners who take on the funding and charge for that too. We love that when they do. But we find the most confusing thing is this, that we tell the client, you make ownership changes to most of your assets, and you make beneficiary changes, possibly, we have to talk through it, on retirement accounts and life insurance. But they get very confused, and they still think they have payable on death designations for bank accounts and things like that. So what we tell them, first of all, your brokerage accounts that are not retirement accounts, we register those in your names as trustees of your trust, or we open new accounts depending on the institution. So that's treasury bills, money market accounts, CDs, brokerage accounts that are not retirement accounts. And we need to make sure that the institution does not consider that change in account name as an early withdrawal on CDs and things like that. Same thing with bank accounts. We can, in many states, you can pass small accounts, or in California up to $150,000. In Kansas, I believe it's $20,000. You can pass small cash accounts free of probate with a small estate affidavit or similar. But for the most part, we like to have all the bank accounts in the trust, not change the trust, the accounts, checking accounts or checks or anything, but still behind the scenes change it. Even safe deposit boxes. We want to enable the successor trustees to be able to step in and handle things upon incapacity and death and have it go the right way, not have it go, not add a child to the account as joint tenant, because then it doesn't go the way they intend. So that's very important.
Most clients are really concerned that the presence of their trust is going to show up on their check. And one of the things that I reassure almost every client, because they seem very concerned about it, is, does that mean that my name is going to be John Smith, trustee of the Smith Family Trust? And the answer is no. That name will stay the same. So it might be John and Mary Smith on the bank account. Now the bank statement each month is going to come in the name of the trust. So it may say the Smith Family Trust or John and Mary Smith, trustees of the Smith Family Trust, on that bank account, on the bank statement, but it doesn't change the checks. And it seems like clients are very concerned about what appears on these checks, and they're almost embarrassed by the fact that they have a trust, although they should be proud of that. Yeah. But they don't want that to be apparent to the world necessarily. And so one of the things that I find here is that I'm constantly reassuring clients that it's really not going to change much about the way they live their lives. They're still going to, the interest income from these bank accounts, by the way, is still going to be showing on their Form 1040. It's not going to go to a trust for separate reporting.
And it's still their same Social Security number, and they get confused about that too. They think it's the trust is a separate entity, which it is not. And another confusing area for our clients is that they think that holding assets in a revocable living trust creates asset protection for those assets. And so we have to go through that explanation as well.
And so asset protection is one of the biggest goals we see emerging with clients these days. And when we go through the asset protection discussion, this is pretty much what we say. There are several layers of asset protection. The first layer is insurance, and that's one of the reasons that people buy long-term care insurance, is that with long-term care insurance, they are creating a deposit that can be used to pay for long-term care, and it's going to protect the assets that are going to pass on to the beneficiaries in the long run, and it's trying to make sure that that not all the assets are exhausted by using it to pay for long-term care and home care when a person passes away. Other types of insurance like FDIC and umbrella policies are just part of the basic asset protection strategy. The next level of asset protection we encourage our clients to look to are entities. And it might be a limited liability company. That's usually the first layer of defense when somebody has a business interest that they want to protect, or real estate, like a real estate investment property that they want to protect. Going a step further, when we start to look at succession planning, we turn to family limited partnerships. These have the ability to allow us to transfer these interests to loved ones, while at the same time maintaining asset protection features. Irrevocable trusts are another important way that we provide asset protection to our clients. We do that as part of the basic estate plan. If we use a bypass trust in our basic estate plan, we're putting in an asset protection feature. Same thing when we use irrevocable trust when we pass it down to the children. If we create beneficiary controlled type features where we have distribution trustees, or even allowing the child to serve as a trustee with a backup as an independent trustee, we can provide asset protection to that child. Now, depending on your jurisdiction, you might be able to set up what's called a domestic asset protection trust. And this is an irrevocable trust that in some states like Nevada, Alaska, South Dakota, Delaware, those are considered by many of the 4 top states to do this. You can create a trust yourself, and it's not common that you can create a trust yourself and have it have asset protection features. But if you go through a incubation period in these states where no lawsuits surface, then the trust becomes an asset protection type trust that is more difficult for creditors to penetrate. The ultimate in asset protection is often considered offshore asset protection trusts. And with these offshore asset protection trusts, you're usually looking at larger estates, although this number is getting lower and lower. In the past, the threshold has been considered $10 million, but I've heard many say that it's more like $5 million now. And I've seen people look to asset protection trusts, offshore asset protection trusts, with as little as $1 million. The price tag is a little bit higher. It's usually a little bit more expensive to set these up because you're usually looking at offshore jurisdictions such as the Cayman Islands or the Cook Islands or other desirable venues outside the country. But this is considered by many to be the ultimate in asset protection. With regard to cash accounts, because that's a concern for many, Leslie had experienced this past year with a client where they basically used revocable trust to increase their FDIC insurance.
Right. We actually took money out of the single settler trust and put it in a joint settler trust and added they wanted it all to go to the husband's sister, but we added a couple of 2% beneficiaries. We got 5 unique beneficiaries. And we even called the FDIC call center line. They're unusually responsive if you ask for a living trust specialist, and they will even give you a legal opinion from their legal department, so you can verify that for your client, that it really increased the coverage dramatically, because these people only wanted to hold cash. They're older, very set in their ways, and they only wanted to hold cash in bank accounts, but they wanted it insured. So you can even use that as a means of protecting your client's funds.
Just to illustrate how it works, the typical account, whether it's a single account or a joint account, has $250,000 in protection. So this is the principal and interest that's protected. So individual, joint, retirement accounts also have that $250,000 protection level. But when you, so single ownership accounts, these include accounts in the owner's name, accounts established for the benefit of the owner by agents, nominees, guardians, custodians, conservators. It also includes a sole proprietorship type account. So all these accounts are included. And a lot of people think that if they open it in branch 1 of a Bank of America and then have another branch out in the suburbs of Bank of America, that's a separate account. Not so. Branches are considered all one bank. And joint accounts are insured separately from single ownership accounts. So a lot of people think that, well, if they're a joint owner, that they've given up part of their single $250,000. It's really considered a separate account, and you have a separate $250,000 threshold. With the revocable and irrevocable trust that Leslie was referring to, with a revocable trust, you could set up a joint revocable trust, and it's set up per beneficiary per grantor. So a joint revocable trust set up by a husband and wife with 3 children is insured up to $1.5 million. So you can see that we have 3 times $250,000 for the children for one grantor, 3 times $250,000 for the second grantor, giving us $1.5 million. Retirement accounts, as I mentioned, are separate accounts. So whether it's a Roth or traditional IRA account, they're considered as one retirement account, and you have one level of $250,000 protection. Because many of our clients have several $1 million in bank accounts, and that means they have to go to separate institutions to get the they have to open deposits in more than one institution to be sure they get the FDIC insurance for all their assets. And despite the fact that Warren Buffett is now saying our banks are safe, I think it's always a good idea to be act with caution with regard to this type of insurance. As far as funding of investment accounts, now we're looking at brokerage accounts, and once again, we need to change the title of these accounts to the the trust name. So we have to change it from the individual's name to the trust name. And the client may need to complete a new account application and present a copy of the certification of trust, which we provide as part of our basic documents to the client so they can make these transactions. And just like we do with a bank account, we want to be sure that after we change the title of this investment account, that we confirm it with the next account statement, making sure that it's now titled in the name of the trust. It's such a stressor to come across this after somebody's had an accident and that looks like death is imminent, to rush around and all of a sudden find that investment accounts or bank accounts were still owned by the individual themselves and not in the name of the trust, and it often can lead to unnecessary probates. With regard to asset protection you get with these investment accounts, we have $500,000 of protection for failed brokerage firms under SIPC, the Securities Investor Protection Corporation Act. So this protects the customers of broker-dealers who are members, and so that's one thing that most broker-dealers are protected by this insurance. It includes a maximum of $100,000 for cash claims, but $500,000 for equity and bond type claims. So securities in the client's names are automatically returned and not covered under SIPC. Commodity futures and investment contracts, like limited partnerships, are not covered under this act. So you have to pay attention to the type of accounts that the client has and make sure that there is some asset protection for some of these assets. Stocks and bonds not held in investment accounts. There are two ways to transfer these stocks or bonds to the trust. First of all, you could open a brokerage account and take them out of your individual names and put them into street names. So that'd be one way to do it. Or you could work directly with the corporation that you own the stock in, and it's working directly with the transfer agent for the corporation. Usually it's the secretary of the corporation, and just have them reissue the actual stock itself in the trust name as opposed to your individual name as the trust owner.
For personal effects, in the old days, we used to dispose of personal effects via the will. Today, we don't like to use the will at all. We do a blanket, basically a blanket assignment of personal property to the trust, and then we dispose of it either by a memorandum that can be incorporated into the trust, which the client can change at will, or we put the provisions in the trust. So we do not use the will typically anymore. We just administer it through the trust.
So we're looking at household furnishings and appliances and fixtures, works of art, motor vehicles, pictures, collectibles, personal wearing apparel, jewelry. All these are included. Some of the most common questions we get about these personal effects are, does it include pets? And the answer is yes. Pets are treated as personal effects, and they are treated as transferred into the trust with regard to this assignment document that Leslie was referring to. Livestock is another type of asset. Now, livestock, you might think, well, isn't that a big pet? And it is. And this varies from state to state. Some of the agricultural states do not consider these personal effects, but business-type assets. So you need to be careful how your state considers it. But generally, livestock, whether it's cattle or horses or goats or sheep, whatever it might be, are transferred into the trust with this assignment of transfer. So once these are transferred in, one of the concerns of many clients is, how do I get this property out? And we have a personal property memorandum that's part of our standard documents. And with this personal property memorandum, it's the typical list. Many clients come in for the first meeting with a long list of who they want to receive certain assets. And we basically give them that work to do by transferring it to a personal property memorandum. And this allows them to identify the person they want to receive this property, identify the property itself, and whether they want this transfer to occur after they pass away or after both they and their spouse passes away. Personal vehicles are a big issue And many of our clients are concerned about how these personal vehicles are titled. So they can be titled in the name of the trust, which in my opinion is the best way to do it. But some clients prefer to leave their vehicles outside the trust. And when they do it that way, they tend to use transfer and death type.
Right. In California, we can transfer vehicles extremely easily after 40 days have elapsed. It's just a form at the DMV, and you show up with a death certificate. So it's very simple. So in California, we tend not to put vehicles in the trust, although they could. I mean, we just tend not to. And then in states like Kansas and Missouri, or I think Missouri, you can do transfer on death deeds, transfer on death designations as well. So it depends on the state, but typically you'll find most people do not fund them in the trust, although they can, and some do. Yeah.
Okay, and others just want to continue to own the property jointly because they think that's the easiest way to transfer it. The risk, of course, is that they'll both be killed in the same accident. So the important thing is to make sure that this property avoids probate. Although there are dollar levels, as Leslie mentioned before, 150,000 or so in California.
Just transfers and things.
Yeah. So these transfers end up being below the thresholds that trigger a probate. But why take the risk? There may be other assets outside the trust that, when added together, take you above that level. I think these are, since they're titleable assets, I think they're easily, in my opinion, titled in the name of the trust. Another concern with regard to personal vehicles is that by having the asset title in the name of a trust, that they're exposing the assets of the trust to lawsuits and to creditor exposure. And the short answer to that is we're talking about a revocable trust. The trust assets are exposed no matter what. There's not asset protection for a revocable trust. So the quick answer when that comes up is the revocable trusts do not provide asset protection, and the asset protection they have, whether the car is in the trust or out of the trust, is the same. Now, what the presence of a personal vehicle and owned by a trust could do is give the impression to somebody that you've had an accident with that you have deep pockets because you own the property in a trust, and that may change the negotiations or the proceedings with regard to how any settlement type occurs after that accident. As far as qualified tuition plans are what I call in Never Never Land. So estate tax Never Never Land. If the parent who set up the 529 plan passes away, then it's not included in their estate. It's considered an asset of the child. If the child passes away, it's not considered an asset of the child. It's considered an asset of the parent. So I call that estate tax Never Never Land. But it's important to look at your rules because they can vary from state to state. And it is possible to put language in our trust, which we do as a standard practice in our trust, identifying 529 plan assets as part of the trust assets, and enabling the trustee to make decisions with regard to those 529 plans. So there are several ways you can handle this. That's the way I think most people do, is to make sure it's included as a trust asset. With regard to oil and gas and mineral interest, in some states these leasehold interests in oil, minerals, and gas are treated as contractual rights. In other states they're treated as real estate interests, and you have to be aware of how they're treated in your state. So, and you also have to, because there really are actual ownership rights to oil and gas and mineral interests, and also actually leasehold rights to these. So you have to be sure you know what kind of interest your client has and how your state treats them. So if it's a contractual right, we can transfer that contractual right into the trust. If it's a real estate right, we're going to have to create a deed that transfers the title to the trust. But the important thing is we want to be sure we get this investment interest into the trust, because for some families this is substantial wealth and substantial income. We want to make sure that it follows the disposition pattern of the trust. As far as anticipated inheritance, gifts, lawsuits, judgments, or lottery awards, we always ask our clients about these as part of our initial questionnaire, because I think it's important to know whether these interests are coming. We want to make sure that the receipt of this property, if it comes between now when we establish the trust and when it's eventually, when the first or second death occurs, that this property passes according to the wishes of our grantors. And so if to the extent we can, we want to make sure the lawsuit judgment or lottery award, that those interests are assigned to the trust. When the property is received as a gift or if it's received as an inheritance, we want to make sure that it's assigned to the trust and it's going to pass that way. Now, in some states, the clients want to keep this property separate because inherited property is considered separate property, even in a community property state, as long as it's not commingled. Same thing with gifted property. So in some cases, this could lead to the establishment of a separate trust for that property because they may want a different disposition scheme for that.
Similarly, business interests should be transferred to the trust, whether it's a sole proprietorship, partnership, or limited liability company or corporation. We typically prepare an assignment where the settlor or settlers will assign it to the trust, but then we need to also go into the books of the company and reissue the shares of stock or reissue membership certificates or some way also memorialize it on the books of the company or the entity. And so it's pretty straightforward, but we do like to ensure, because a lot of people we've noticed do not follow through on this step at all for the business entities, and we want to make sure they're transferred to the trust as well.
For many families, this is the biggest asset they have, that business they built for 20 or 30 years of their life. And so we want to make sure that, first of all, that the value of this business interest is going to be available to the family, and we'll talk more about buy-sell agreements here in a minute. But we want to make sure that this interest gets into the trust so that it doesn't end up going through probate. We also want to make sure that there's a formal way to transfer this interest so that this property can actually, the family can receive the benefit of it. So buy-sell agreements are contractual arrangements, and with our document preparation system, we can create very sophisticated buy-sell agreements, and this succession planning that we do with these buy-sell agreements is critical to families. As I mentioned before, often the biggest asset that a family will have will be the sole proprietorship interest or the limited liability company interest or the partnership share or the corporate percentage that the person owns of a family business. And making sure that this wealth is available to the family, because usually these, if they're co-owners, they don't want they don't want to share the ownership or share the decision making with the surviving spouse or the children. Now that the founder or the original owner is deceased, these other owners want to buy them out. We want to make sure that that arrangement is fair. If we're talking about a sole proprietorship interest, we can usually establish a contract with a competitor. And I know that seems odd that you would go to a competitor and say, hey, I want to be sure that my family's taken care of, and I have this business I've established, and you and I have been friendly competitors for years, and would you be interested in buying my customer list, or would you be interested in buying the assets of my business, or taking over my location as another location for your business after I pass away? And let's enter an arrangement. I mean, you're a sole proprietor, I'm a sole proprietor. Let's make sure that our families benefit from the businesses we've built over these years. And it's possible to do that with buy-sell agreements. So again, we're talking about a contract between entity owners, and some of the advantages of this, it ensures that there's a market for the interest, because we don't want this business to fail within months after the key person passes away. It provides financial security during the retirement of this owner, if the buy-sell agreement triggers early enough, or for heirs after they pass away. It provides protection against unwanted shareholders, liquidity for the family after this passing. It ensures a smooth transition of ownership and stability. S corporation status can be preserved if the entity is an S corporation. It can also establish a formula for establishing the value for estate and income tax purposes following the person's death. Now, there are several ways that this is done. It could be done by means of a cross-purchase. Usually we do this when there are just a handful of owners of a business. They'll each buy insurance on each other, so they have the financial ability to buy out the person's interest. So each owner buys life insurance on another so that they can actually buy out that family's interest after they pass away. Usually income tax isn't an issue, because when the person passes away, there's a stepped-up basis in the value of that interest. So when it's purchased, then it ends up being a no gain or loss type transaction, and the family receives the life insurance proceeds come in tax-free, and the purchase itself occurs tax-free. So it ends up being almost a non-taxable transition. When we're talking about redemptions, where the corporation or the business entity owns the insurance itself, there could be a greater likelihood that there'll be some tax consequences. So we have to be careful with how we structure those. One of the emerging ways we see, one of the emerging new owners we see of these business interests, and one of the buyers of this decedent's interest after they pass away, are ESOPs, employee stock ownership plans. It's a type of retirement plan. And this is when a business has been around a while. It has a core group of employees that have been around from the beginning. And the owner was concerned that they would lose their jobs and if they were acquired by another company or if the company failed. And so what they do is establish an employee stock ownership plan where the employees basically take over the ownership of the corporation by buying out the owner's estate of that stock. And that leaves the family in good shape, and it leaves the company in good shape. Usually these types of arrangements are funded with life insurance or possibly the entity's earnings. There are tax consequences, as I mentioned before, of doing a cross-purchase versus a redemption. So we have to think about the income tax treatment. We have to think about whether it's a sale or dividend. What's the basis of these shares? Is life insurance going to be included in the decedent's estate? We want to make sure it's owned in such a way that it won't be. And we also want to look for a procedure that's fairly simple and easy to execute. As far as determining the price, here we're governed by Code Section 2703, and whatever arrangement we come up with, we want to make sure that we pass the standards set out in that corporation, or excuse me, in that code section. And so we want to make sure we have a bona fide business arrangement that is not a device for distributing the profits of the corporation. In order to do this, one of the requirements is the shareholder has to be obligated to sell at that price either during life or at death. The formula can't change. The formula has to apply in life and at death, and it has to be really an arm's length agreement. So what we're doing with this is we're trying to make sure that we establish a fair and reasonable price, not only for the family, but also for appraisal purposes and passing purposes in the eyes of the IRS. So usually we set this option to purchase to set a price that fixes only a maximum. We don't want to set a price that's going to be low. We also have to be careful of rights of first refusal, because if the person refuses, that means that can now be offered to the market, and it could end up with a dissolution of the ownership with owners that we may not want to have.
Funding trust with real property is a very, very important part of estate planner's practice, and a huge part of our practice. Transferring property to revocable trusts, irrevocable trusts, and entities. Basically, it involves preparing and executing and recording new deeds for each property in the county where the property is owned, and we have to sometimes get out-of-state attorneys to help us with out-of-state property. We also have to file in California preliminary change of ownership reports, so we're not reassessed when we make those transfers. We could rely on a trust schedule at the back of the trust, although we don't want to. But if worst case scenario, when people tend to refinance their property and forget to get it back in their trust, we could go to court here in California on a petition and try to get it in the trust. But we have to be very careful with not triggering reassessments, property tax reassessments, when we transfer into entities and when we transfer to irrevocable trusts and things like that. So we have to be very cautious. Same thing with timeshares. They may be handled exactly the same way as real property with a deed, but some are more contractual, and then you fill out the paperwork. We handle all the paperwork for our clients, these types of things. And with real estate, if they have the forms, you have to get them typically from the company, the timeshare company, and then like everything else, we have to make sure that it actually went through and that they have that on record.
As far as subtrust funding, this really is just a process, and we've been talking about all these trust funding rules. They can really occur in several different stages. I mean, it occurs for the first time when we establish the revocable trust in the first place. We want to make sure everything gets into that revocable trust. But we could go through this whole process again after a person dies, and now we have to change the titling from the initial joint trust or individual trust to a subtrust. Maybe it'll be a survivor's trust, maybe it'll be a bypass trust, maybe it'll be a Q-tip trust. But we have to make sure the funding is done correctly. And because for the plan to operate not only at the first death and maybe the second death, but from that point on, and avoid taxes at all the different levels and carry out the initial plan that was described in the very first meeting. We have to make sure that the proper funding occurs all along the way. So we could be making outright distributions. We make those to start with. We could be identifying the sub-trusts that need to be created. Usually when we do this, we create a spreadsheet. We list out all the assets and we spread them across to see what's going to go in the survivors trust, what's going in the bypass trust. We want to make sure that we meet the allocation formulas set out in the original document. So we establish these targets for allocation and funding. Then we do the allocating of the assets to the sub-trust. This may involve retitling of bank accounts and real estate all over again, just like we've gone through with the initial funding. We select an allocation date. I tend to prefer the date of death and try to treat everything as occurring on that date. Others choose a date later after that and go through an administrative trust period. It's just a matter of choice. It can be done either way. Preparing an asset allocation agreement and diagram so that the family and clients understand what's happening. Implementing the sub-trust allocation, completing the trust administration by distributing these assets in the appropriate way. So this process, we generally follow some traditional rules of thumb as we do this. So we might fund the primary residence to the A trust, and the reason we would do that is so the surviving spouse can take advantage of their Section 121 capital gain exclusion. They received a stepped-up basis on part or all of the residence when the first spouse passed away, but there still may be gain potential that occurs as a result of appreciation after the first spouse dies, or because they didn't get a full stepped-up in basis on the first death. We could make loans to the children, and generally these are allocated to the A trust to avoid the spouse having a fiduciary duty to enforce the obligations, because usually they have a tendency to forgive them or not enforce the payments. And if it's in a B or C trust, which is an irrevocable trust, there is a fiduciary obligation on the part of the trustee, usually the surviving spouse, to enforce that obligation. Closely held businesses and unproductive land are usually not placed in C trusts because that C trust, a Q-tip trust, is expected to produce income, and the surviving spouse can demand that it produce income, and we don't want to be put in a situation where we have to sell the business interest and replace it with other assets or sell this land that they want to keep in the family to produce income for this trust. Dividend reinvestment accounts should not be allocated to trusts which require income to be distributed either, such as the two marital trusts, the survivors trust and the Q-tip trust, because if income if the person needs the income to live, we don't want to have them in a situation where they have to sell assets in order to get an income stream that they can live from. One of the big issues that I see with the primary residence, the first bullet on this slide, is sometimes we split it between two trusts because the primary residence is the biggest asset in the estate. That happens quite a bit in California, and it has to be allocated between the B trust and the A trust, which means that part of that sale will not be eligible for the Section 121 capital gain exclusion. And it could, one part's getting a stepped-up basis when the surviving spouse dies, and the other part isn't because it's in the bypass trust. So it creates some complexity. So we try to put it in one trust or the other, usually using loans between the two trusts to equalize it and make sure that the values are fair.
I fill out retirement beneficiary designations for clients whenever possible. This is an area that's very confusing to clients, and they often try to change the retirement plans into their names as trustees of the trust. They don't understand because they think everything's supposed to be in their trust. They think they're supposed to own their retirement plan assets that way. But the trust should never own the asset. We can and do change the beneficiary designations. In Wealth Council, our docs here, we have conduit trust language to make it a look-through trust, and we tend to, at our practice, tend to have lifetime beneficiary controlled trusts for our clients, and we create special beneficiary designations to split the proceeds before they hit those trusts so that the benefits can be stretched out over each beneficiary's life expectancy. That's a very important thing to do, and we've had it vetted by Natalie Choate. If anybody wants a copy of our beneficiary designations, please let us know. Just email us. But again, go ahead, Randy.
This is often very important to financial advisors. Financial advisors, one of the first things they look to is to see if conduit trust language is available, because they want this to pass through in trust form to the children. because often they may be named as investment advisors, or they've established relationships with those children, and they want to make sure that that they can continue to manage the assets for those children. So for many financial advisors we work with, one of the first things they look at when they're reviewing estate plans is how does the plan deal with trust. If they see that it does not have conduit trust language, or language that is favorable to the management of these assets after the spouses pass away, then they'll often look to change that. As far as naming beneficiaries and what the best way to do that is, using conduit trust language, one of the big concerns is, will this beneficiary be able to draw the money out over their life expectancy, or do they have to draw it out over the oldest beneficiary's life expectancy? That's what conduit trust language is all about. If we establish, first of all, if the retirement plan itself breaks into separate shares, and if those separate shares go into separate sub-trusts for each of the children, we have the conduit trust mechanism working, and each child can have a distribution based on their own life expectancy. So many people don't realize this, but the children can't wait. The spouse can wait. So surviving spouses have special rules that allow them to postpone taking distributions until they turn retirement age, depending on which elections they made following the death of the first spouse. But children don't have a choice. They have to start taking minimum distributions the year after the decedent dies. So we also want to make sure that the retirement plan administrator sends a letter confirming these changes. This is one of the most important steps you can take, is to confirm that these trust funding allocations that you're making and the designations that you're making have actually been recorded by the asset holder.
Life insurance is another thing that is not, we don't change title, we change the beneficiary designation, most typically to name the trust the beneficiary, unless we're creating an irrevocable life insurance trust, in which case we would name the trustee of the ILET the owner. Typically we would not change the owner, we would just change the beneficiary designation to be the trust.
As far as funding issues with regard to life insurance, Leslie already mentioned these, but generally we designate the trust as the beneficiary of the life insurance policies. If we want to make sure that this life insurance is not going to be included in the estate, we'll handle it differently. We'll set up an irrevocable life insurance trust. If you name the trust as the primary beneficiary, name the spouse, partner, or children as the secondary beneficiary. So we want to have multiple beneficiaries named, so there's no chance we're going to go through probate with this often big asset coming into the estate. Each insurance company has its own preferred format for designating a trust as beneficiary, so you're probably familiar with the insurance company that you're working with and what they're looking for, but be careful because not all insurance companies are the same. You want to make sure that the insurance company confirms that this change of beneficiaries has occurred, because again, this is a big asset that can have a huge impact on the trust. Just a reminder that our purpose in doing this was to encourage collaboration between estate planners and financial advisors. And throughout this presentation, I think you've seen the opportunities that can occur and how the two can work together to create a perfect estate plan that not only is beautiful in the way it's crafted and designed from the very outset, but also in the way it's going to flow through and be carried out for the grantors' lives and for the children's lives after the grantors pass away. And this is an opportunity to collaborate not only for a short-term period while the plan is being drafted, but for the long term, as these clients come in for annual reviews, and the estate planner and the financial advisor can work together to make sure that all the pieces are in place, and any changes in the law that have occurred, any changes in the asset ownership, that the two are communicating to make sure that all the assets are in the trust. Thank you very much for listening to this program.
Thank you.